Hi, I'm Kathleen Flamia, founder of the Flamia Elder Law Firm. On October 18, 2018, new rules regarding eligibility for VA pension were implemented by the Department of Veterans Affairs, also known as the VA. The VA aid and attendance benefit is for veterans and their spouses who are 65 or older, served during a period of war, have trouble performing tasks of daily living, and meet certain financial requirements. The aid and attendance benefit can pay up to $26,000 annually via the VA's non-service connected pension. Funds can be used to help pay for long-term care, including home health care and nursing home care. These changes in eligibility requirements that went into effect late last year have created new hurdles that veterans and their families must clear in order to qualify for benefits. However, they also provide more opportunities to qualify for these important benefits. The first hurdle involves a look-back and penalty period. This change is one of the most controversial. Unlike Medicaid, which has a 5-year look-back period to catch any disqualifying asset transfers, the VA has not previously imposed a transfer penalty on veterans who restructured their assets to qualify for the aid and attendance pension. The new rules change that. There's now a look-back period of 36 months when applying for needs-based pension benefits. Any asset that was transferred for less than fair market value during the 36-month period immediately preceding the pension application will result in a penalty period of up to 5 years. There are a few exceptions to the new transfer penalty rule. One exception involves transfers to children. No penalty will be assessed if the transfer was to a trust established for a child who is incapable of self-support prior to the age of 18. Also, there is no transfer penalty imposed if the claimant's net worth would have been below the net worth limit already, regardless of the transfer. There's no penalty period if the transfer was the result of fraud, misrepresentation, or unfair business practices related to the sale of financial products. And finally, the only transfer subject to the look-back and transfer penalty rules are those that occur on or after October 18th of 2018. It's important to know that buying an annuity won't always work as an asset transfer strategy. If the annuity can be liquidated, then it is counted as an asset. If the annuity cannot be liquidated, then distributions from the annuity are considered income. If the annuity was purchased during the look-back period, then a penalty will be imposed. How is the penalty period calculated? It's complicated, but I'll do my best to explain it. The divisor used to calculate the penalty is the maximum annual pension rate in effect as of the pension application date, at the rate of the aid and attendance level for a veteran with one dependent. In 2019, this number is $2,230 and is applicable to all claimants regardless of marital status. The penalty period will be recalculated if all or part of the gifted money is returned. This is also referred to as a partial or total cure. The second major hurdle that applicants will need to clear involves net worth. There is now a bright line rule regarding the net worth of a veteran. This amount is currently set at $127,061. This number will increase annually with the increase in Social Security benefits. If the veteran or other claimant has net worth over the threshold and does not qualify for benefits, he or she can spend down assets by purchasing goods or services for fair market value for any household relative. Note that a homestead owned by the veteran is not included in the net worth calculation. However, there is a 2-acre limit imposed on the homestead. If the claimant's homestead is over 2 acres, then other rules apply, and the value of the property in excess of the 2 acres may be included in the net worth calculation. Some items aren't counted as part of net worth. For instance, the value of personal effects suitable to and consistent with a reasonable mode of life is not included in the asset calculation. This would include personal transportation vehicles and most household goods. If the claimant has any income left over after subtracting the unreimbursed medical expenses, then under the new law change, the excess income is now added to the claimant's net worth. And now for the good news. There are more medical expense deductions. The new rules provide an additional activity of daily living, also called an ADL, to include assistance with getting around in the home. The rules also define instrumental activities of daily living, known as IADLs, and set out specific instances when expenses for care that include ADLs and IADLs may be deducted from income. The rules also specify when room and board at a care facility other than a nursing home may be deducted from income as a medical expense. Is this complicated? Yes. That's why working with a professional, VA-accredited attorney can be helpful. If you have questions about these new rules, or if you would like to discuss whether you or a loved one could qualify for VA pension benefits, just give our office a call.